Imagine you're right in the hot seat. You're the engineer of record on a massive public infrastructure project. We're talking millions of dollars on the line, contracts are all signed, and construction is literally about to start. But you've just discovered a flaw. It's a hidden risk in the design that technically meets the bare minimum code, but you know, deep down, it could lead to premature deterioration. And to make matters worse, your boss is telling you to just keep your mouth shut to avoid a massive financial delay claim. So what do? Well, welcome to today's explainer. We're going to tear apart a classic National Professional Practice Examination, or NPPE, ethics question to show you exactly how to navigate this ultimate dilemma, your professional duty versus a legally binding contract.
Okay, let's look at our roadmap for today's training class so we can systematically break this down. We've got 1. The engineering dilemma. 2. The NPPE core topic. 3. The ethical framework. 4. Analyzing conceptual traps. 5. The correct professional action. And 6. Terminology and final takeaway.
Section 1. The engineering dilemma. Let's set the stage.
Here is the specific real-world scenario you're being tested on. You are a professional engineer, acting as the engineer of record for a public infrastructure project. You discovered during a post-design peer review that a design assumption made by another licensed engineer within your firm may have materially understated long-term fatigue loading. Now, the design complies with minimum codes, but new monitoring data suggests a real risk of premature structural deterioration. So it's not going to collapse tomorrow, but it is going to degrade way faster than it should. The client has already awarded the construction contract. Revising the design now, that's going to trigger some substantial delay claims.
Now, this is where it gets really interesting. Notice management's explicit directive here. Senior management basically instructs you to remain silent unless the regulator specifically requests additional information. They're arguing that the firm has discharged its contractual obligations and, hey, the design technically satisfies existing regulatory requirements. This right here creates the absolute ultimate conflict between corporate hierarchy and your professional duty.
So what's your play? Here's a bird's-eye view of your 4 choices. A. Respect management's direction, since contracts are fulfilled. B. Document it internally, but defer external disclosure. C. Advise the client promptly of the concern and recommend a reassessment. Or D. Withdraw from the project entirely without notifying the client.
Section 2. The NPPE core topic. Let's hit pause on our scenario for just a second. What exactly is the exam designer trying to measure here? Well, this is a textbook test of professional ethics and professional accountability. They want to see if you can prioritize public safety, transparency, and client welfare over things like contractual technicalities, corporate pressure, or, the fear of massive delay claims.
Section 3. The ethical framework. To really solve this, we need to nail down the foundational theoretical concepts that govern our profession. As an employee, yes, you absolutely have a duty of loyalty to your management. You shouldn't just needlessly undermine your employer. However, and this is a big however, as a licensed professional engineer, your paramount, unshakable duty is to the public welfare and to your client. A legal contract or a corporate directive never absolves you of your professional obligation to speak up when you spot a legitimate risk. Code compliance is just a minimum standard. It's not a shield to hide behind when new data proves the design is flawed.
Section 4. Analyzing conceptual traps. Let's look at the wrong answers.
Test designers absolutely love to lay traps for you. They build wrong answers that sound incredibly reasonable if you don't fully grasp the ethical framework. So let's break down these 3 traps to see exactly how they tempt candidates away from their true ethical duties.
Option A is what we call the blind obedience trap. It suggests you just respect management's direction because contractual obligations are fulfilled. This tempts test takers who falsely believe that fulfilling a contract and following senior management's orders somehow overrides independent professional judgment. Just because a design met the bare minimum regulatory standard when it was submitted doesn't mean your ethical duty just vanishes the moment concerning new data comes to light.
Then there's option B, the wait-and-see trap. This one suggests documenting the issue internally but deferring external disclosure unless failure becomes highly probable. This is incredibly dangerous. It basically kicks the can down the road, waiting for a failure threshold rather than proactively addressing a known risk. Engineering ethics require proactive protection. You don't just wait for a structure to be on the verge of collapse before you finally decide to send a warning email.
And option D? That's the liability avoidance trap. It suggests withdrawing from the project without notifying the client to protect yourself from negligence claims. It really appeals to candidates wanting to just run away from a sticky situation.
But silently walking away while leaving the public and your client exposed to a hidden hazard, that is a severe dereliction of duty. It's essentially abandoning your client in the dark.
Section 5. The correct professional action.
Which brings us to the actual correct answer, option C. You must advise the client promptly of the newly identified engineering concern and recommend an appropriate technical reassessment. Why? Because proactive disclosure is both legally and ethically required when your professional judgment dictates a risk exists. You're the engineer of record, you have the new data, you have the technical understanding. It is your absolute duty to ensure the client is fully informed so they can make an educated decision about their own infrastructure.
And this brilliantly illustrates the golden rule of engineering ethics, highlighted right at the end of option C, notwithstanding potential contractual or financial consequences. I want you to really think about that. It means that angry project managers, massive delay claims, and huge financial headaches never, ever trump engineering integrity and the client's right to know. You literally have to be willing to have the hard conversation.
Section 6. Terminology and final takeaway.
Before we wrap up this explainer, let's lock in the exact vocabulary used in the exam prompt to ensure total comprehension. First up, engineer of record. This isn't just a fancy title, it is a profound legal and ethical status. It means you are the licensed professional who takes ultimate responsibility for the design and actually seals the documents. The prompt specifically places you in this role to emphasize the massive weight of accountability resting directly on your shoulders. You can't just pass the buck to the engineer who made the original assumption. You stamped it. You own it.
Next is fatigue loading. In civil and mechanical engineering, this refers to the cyclic, repeated stresses placed on a structure over time. Think of it like heavy traffic continuously rolling over a bridge, day in and day out. Over years, this repeated stress can lead to microscopic cracks and eventual structural deterioration. That is the specific technical risk in our scenario that was understated.
And finally, materially understated. This legal and technical phrasing means the error wasn't just some tiny, insignificant rounding error. It was significantly underestimated to a degree that it practically impacts the structure's integrity or lifespan. It's a serious oversight, which is exactly why it triggers your duty to act immediately. So, let's bring it all together for our final educational takeaway. If you take away just one thing from this entire class, make it this. Proactive safety disclosure always supersedes passive contractual compliance. You can use this core rule to navigate almost any accountability question the NPPE throws your way. Contracts and minimum codes, those are just baselines. Your professional judgment and ethical duty to protect the client and the public, that is the absolute ceiling.
I want to leave you with this final, provocative thought. If your design meets the bare minimum code, but you possess hard data proving it will prematurely deteriorate, whose side do you think the law and the ethics committee is really on? Think about that for a second. The weight of an engineer's stamp isn't just about proving you can do the math. It's about proving you have the courage to stand up for the truth, even when it costs money. Thanks for joining me for this explainer, and keep that integrity front and center.